Assalamu alaikum friends, you are watching Tax Dosti videos. This is part 13 of the Sindh High Court judgment on section 7E which they declared on October 2022. Today is 2nd of February 2023. We are going through the judgment paragraph wise and every paragraph has its own part. You are watching part 13. This is paragraph 13 of the judgment. The judge says that in the Indian Constitution of 1949, there exists entry 82 of list 1 of the second schedule, which is identical to our entry 47. Whereas for entry 49 of list 2 of 7 schedule to there is more or less similar to our entry 50. क्या हुआ बेबी? Hello, video बना रहा. In the case reported as Bhagwan Das Jain versus Union of India, All India Reporter AIR 1981 volume, Supreme Court 907. ठीक है. The issue for consideration before the Supreme Court of India was whether it is open to the income tax officer while computing the liability of an assessee to tax under Income Tax Act 1961 to include in the income of assessee any amount calculated in accordance with section 23(2) of the Act. Viewers, this section 23(2) of the Act is that if a person has more than one house or two houses, the third house will be considered to have earned deemed income. So, as the judge writes, in respect of a house in occupation of the assessee for the purpose of his own residence, it was contended that inclusion of any amount under section 23(2) of Act means Indian Income Tax Act 1961 in his income was unconstitutional, as there could be no income at all in such a case accruing to him in the true sense of that term. The liability that was sought to be imposed under the Act in respect of his residential house was therefore in its pith and substance a tax on the building falling under entry 49 of list 2 of second schedule to the Constitution, and as Parliament could not impose the said liability under a law made in exercise of its legislative power under entry 82 of list 1 of the 7th schedule to the Constitution. This is, we are talking about the Indian Constitution, which authorized it only to levy taxes on income other than aggregate. The Indian Supreme Court didn't agree with this proposition, held that the tax levied was on the income, though computed in an artificial way from the house property and not on house property. From house property, not on house property. Hence, entry 49 of list 2 of 7th schedule was not attracted. Similar is the situation in the instant matter, meaning that in this case, the Sindh High Court is deciding a similar matter as was decided by the Indian Supreme High Court, which agreed that it was deemed income, and even if a person is living in his own house and has not given it out on rent, still it can be considered as deemed income that he has given out his house and earning some rental income or capital gain. Similar is the situation in this instant matter, as apparently the tax is on deemed income and not on the immovable property as contended. So many people in Pakistan are saying that no, this is property tax and we are already giving to provinces property tax. This is not property tax according to the judgment of Sindh High Court so far. The judgment of Lahore High Court is awaited still. Deemed income not on immovable property as contended. The relevant finding of the Indian Supreme Court is as entered. So the Sindh High Court is using a Indian Supreme Court which was similar to this. There is one other circumstance which pursues us to take the view that computation of income for purpose of levy of income tax in accordance with section 23(2) of the Act is justifiable under entry 82 of list 1 of second schedule to the Constitution. It is to be borne in mind that the Government of Indian Act 1935 was enacted when the Indian Income Tax Act 1922 was in force. Section 9 of the Indian Income Tax Act 1922 provided for levy of income tax on the basis of bona fide annual value of the property, even when it was in the occupation of the assessee for the purpose of his own residence. Basically, Income Tax Act 1922 and all other acts, income tax acts in Pakistan and in India have levied tax on income from rental income from property, and even in case of 1922 law, a person living in his own home could be taxed for the deemed income coming from his own home. While enacting entry 54 of list 1 of the second schedule to the Government of India Act 1935, the British Parliament must have had in its view the Indian Income Tax Act 1922, which was probably the only law relating to tax on income in force in British Indian then. Meaning that when the Britishers were making a constitutional law of 1935, they would have had in mind the tax law of 1922. So the power under entry 54 was made according to that. Similarly, the Constituent Assembly, while enacting entry 82 of list 1 of second schedule to the Constitution, meaning the Indian Constituent Assembly that made the Indian Constitution of 1951, must have understood that the word income used in entry would in any event include within its scope all items which came within the definition of income and were subject to change in the Indian Income Tax Act 1922, which was in force at the time the Constitution was adopted, the Indian Constitution. That the Constitution makers had the Indian distribution thereof between the Union and the states. In Pakistan, it's federation, and provinces. In India, it's the federation is called union, and the provinces are called states. Article 366(1), which defines agriculture income as defined for the purpose of enactment relating to income tax, and Article 366(29), which defines tax on income as including a tax in the nature of an excessive profit tax. In the circumstances, it would not be wrong to constitute the word income in entry 82 as income which was in force at the time when the Constitution was enacted, when, as observed by this court in the case of Nirvinda, the word income in entry 82 is capable of wider meaning than was what was given to it in the Indian Income Tax Act 1922 or the English Act of 1918. So, basically, in this paragraph, the Supreme Court of India has said that income includes deemed income also, and they have connected it with the Constitution of 1935, their own Constitution of 51, the Income Tax Act of 1922. So this is relevant. You are watching part 13. Let's meet in part 14, where we'll continue with this judgment. Thank you.